You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. Here in Newsfile, we put Ghana first. My guest this morning, Isaac Adongo, he's MP, Bolga Central and Chairman Finance Committee of Parliament. Kojopoku is Executive Director, Institute for Energy Policy and Research and member, MPP Communications Team. Dr. Eric Oduro-San is Chartered Accountant. He's a lawyer. He's former Director General, the Internal Audit Agency. Yao Apia Lati is Partner, Strategy and Transactions, Africa Infrastructure and Capital Projects Leader, Deloitte Africa. We are joined also by Professor Kofi Abochi, Dean of the UPSA Law School. Gentlemen, good morning and welcome to Newsfile.
Good morning. Thank you. How are you?
Right. So I'm going to begin from Professor Kofi Abochi on the freeing, the Nolle prosequi that has been entered by the Attorney General. And in our jurisprudence, the Nolle prosequi is not questioned. And the Attorney General is not entitled to explain to any court, any judge, why he doesn't want to continue a case. But this Attorney General has decided to do something which is very good, that we have applauded. And we understand that on Monday, he's going to be giving explanations as to why Dr. Dufour, his son, and the 6 others who were in this criminal trial over the 5.7 billion Ghana cedi, loss will no longer be prosecuted. Let's quickly hear a couple of people who disagree on the arrangement, and then I'll come to you, Professor Abochi.
I embrace it fully, all right? It's a bold decision. It's the right thing to do. And, we've said it time ad nauseum that we need to improve our law in respect of non-conviction-based asset recovery. This is one of them, okay? Even though we've not written it out in law, but practically, this is what we call non-conviction-based asset recovery. You see, most of the time when we insist on convicting the person first before we recover, it takes years because, you see, these people are often strong people, rich. They get the best lawyers in town, and they can, let me put it crudely, once in a while we have to say it that way. They can get lawyers to delay, okay? And eventually the cases don't end in a conviction. You see, and so then we lose everything. So this is what we call half a loaf is better than none.
Now, but Martin, talking about
half a loaf is better than none. People say
the AG has entered the Nolle prosequi. The normal narrative will be that if you want to play mischief, you'd probably put it this way, that once there is 60% recovery of the amounts lost of the state or alleged to have been mismanaged, it serves to encourage other future possible test cases to perpetuate itself simply because the people within that space would find it more motivational and beneficial to steal so much with the hope that they'll make away with about 40% of the amount allegedly inflicted on them as having been stolen. These are normal narratives that you may have from people who want to play mischief. But
Right. So two lawyers, Martin and Abdullahi, disagreeing completely, opposite directions. Let's bring in the professor and hear from him about where he stands. Even though it's controversial to suggest that this is non-conviction based, whatever it is, because this is not. Professor Abochi.
Good morning, Samson. The reason the two lawyers disagree is precisely because we are in the realm of the exercise of prosecutorial discretion. When discretionary power is invested in someone, that person has a right to exercise judgment. And when people exercise judgment, it is not unusual to have third parties affected or third party commentators disagree on the basis for the exercise of that discretion. So the fundamental premise, the politics will take its course, but the fundamental premise is for us to just reduce things to the barest minimum, and that is in the exercise of prosecutorial discretion, like all discretionary authority under the Constitution. Two key provisions of the Constitution regulates the exercise of discretionary authority. But these two provisions agree on one fact, that the exercise of discretion is not unregulated, it is not unrestricted, and it shouldn't be capricious. And so when a person exercises discretionary authority and we do challenge that, we have to benchmark it against the provisions of Articles 23 and 296. And we would have to challenge it by showing that it is unreasonable. If we are not able to establish that, then we cannot impeach the exercise of the discretionary authority. The point I'll make at this stage is for us to remember that when an Attorney General decides to exercise the power of Nolle prosequi, which forms, among others, like withdrawal, part of the exercise of that prosecutorial discretion, there is always the liberty to recharge the person. There's always the liberty to come back on that. And so it's not as if this is foreclosed for the rest of all time. It is possible that in the future, the Attorney General, this same Attorney General, or some other Attorney General, might decide to reopen the case in respect to the same facts, and the processes might go underway. So the point I'm just trying to stress is that the fact that the Attorney General has come to a conclusion that the circumstances warrant a discontinuance of this case, that there are justifications that back a decision not to prosecute the formerly accused person involved. One can only comment on these, but the authority is vested in the Attorney General. And as I indicated, if we want to impeach it in terms of our own commentary, we'll have to establish that it is unreasonable. So the key question is whether the exercise of the authority is unreasonable.
Mm. Where do you stand? That we have a matter in which the state is said to have lost in excess of 5.7 billion in respect of this particular case. Then the Attorney General makes a decision that because we have recovered 60% of that money, he's comfortable not pursuing this matter any further. So the 60% will be about 3.4 billion. And then the question is, who is taking up the 2.28 billion that will be left?
So let me state one pro and one con, and then I'll indicate what my position is or what I think my position is in this matter. So the pro is this. First of all, when a court or an Attorney General is making decisions on the preference of charges or the determination of guilt on a person, one of the key factors that are considered is the issue of scapegoating, whether or not the offense, the person is a repeated offender, and in this context, whether or not anybody has even been punished in respect of a similar behavior in the past. It would seem that there is a sense of scapegoating here, i.e., even if this had happened in the past, perhaps there hasn't been a prosecution, or perhaps there hasn't been, the state hasn't chased after this to ensure that there's a refund. So the accused person involved may perhaps be facing a scapegoating scenario, being scapegoated for the first time to demonstrate the state's resolve not to tolerate this moving into the future. And for scapegoat purposes, one is confronted with both punishing harshly to make a statement that this shouldn't happen again, but also one is confronted with the reality that this person is truly the first person being punished. Not only is there no template, but this person, unfortunately, is being used as a scapegoat. So should not unnecessarily be unduly punished. These considerations can pull a decision maker in different directions, and the Attorney General will have to make a consideration of whether or not the person should not be unduly punished, given the fact that he's the first person to face similar charges moving forward into the future. So I suspect that the AG might have confronted the fact that we haven't had anybody facing a similar punishment in the past, and so we shouldn't unnecessarily, unjustifiably punish him, or rather subject him to a rather high standard when others might have done this in the past and nothing happened. So the scapegoat effect might have weighed heavily on his mind. So that's one proof.
If if we're talking about precedent, then the point will be that in the bank collapse, matters, the state has incurred in excess of 30 billion Ghana cedis in the cleanup exercise, as the previous government, sought to do. And in those pictures, you will see that our research team put side by side Dr. Dufour and Ato Essien. Ato Essien, the Attorney General the state determined that he had a liability of 90 million to pay. He pleaded and was able to pay almost about 40 million. But he's in jail.
Well, that's correct. Again, first of all, let's be clear. I do not know the exact considerations that went into the Attorney General's decision-making. I'm only second-guessing him, and I'm just using general principles to make a point. And the point I'm just trying to stress is a person making such a decision, especially in respect of someone who might be facing this for the first time or was among a group of people who faced a similar thing at the same time, will consider the scapegoating effect. But the point you've made is equally correct, i.e. the fact that we would have to have a comparator in mind. And the comparator or the comparative framework here, the person involved is probably in jail. If I did hear your figures right, it may seem that Dr. Dufour is paying higher, or rather is paying more than Mr. Ato Essien currently has paid. And
every individual bank and what their liability was.
Correct.
Out of the total of 420 financial institutions that were affected.
Correct. But again, I'm saying again, we are second guessing. But I'm just saying that if one looks at the figures and it seems that the payment being made by Dr. Dufour is proportionately smaller than that of Mr. Ato Essien, who's in jail, then of course there are questions to be raised, and then of course there are concerns in this case in terms of what exactly the metrics and mechanics in arriving at this determination is vis-a-vis another person who's in jail. The truth of the matter is, in many of these decisions, no two cases are alike. One consideration, for example, that is made by a court in the determination of sentencing, the consideration of extenuating circumstances or the aggravating circumstances. Decision makers at the level of preferences of charges also make the same considerations, whether or not there are extenuating circumstances. And those extenuating circumstances might, for example, include a consideration of whether the person has shown adequate remorse, whether the person has cooperated or collaborated in the recovery process, whether the person has even, quote unquote, snitched on other persons and therefore helped the state in the recovery of money from other third parties. The point I'm making is there's so much one doesn't know at this stage, and perhaps we might just want to wait and hear from him on Monday. But there's so much one doesn't know at this stage, and there would be a lot of second guessing and a lot of what if, or if X is that, then Y has to be this way. My point
as a taxpayer, we were saddled with a financial sector recovery levy, which has so far collected some 2.13 billion Ghana cedis. As in, so that we, who didn't do anything wrong, me, the taxpayer, who did absolutely nothing wrong in the bank collapse, which the state spent in excess of 30 billion, I am being asked to pay for the state's decision to spend that money for the recovery or the revival of the industry. As a taxpayer, how do you feel that this is how the problem is being resolved by the people that were accused, particularly in one bank, of a liability of 5.7 billion?
I'm a very unhappy taxpayer in that context, Samson. And there are examples around the world. The too big to fail American scenario. There are examples of how there were consequences and people had to pay certain prices for certain conducts. For example, one of the things that makes me very unhappy is the fact that the people who were at the helm of the regulatory regime in the country at the time, why are we not having answers? These were the people who were supposed to ensure that related party transactions were not only kept to a barest minimum, but in some circumstances just did not happen at all. If you hear some of the stories, it would seem that there were clear cases of fraud. And it does seem that people who were actually paid at the time to ensure that these things did not happen, those persons, I still haven't heard any charges being preferred against anybody, and I'll be happy to be corrected.
You're right. Nobody is standing trial as a regulator or involved in the regulatory exercise over the bank collapse.
In some regimes, you will actually hear cases of regulatory complicity because these shouldn't happen. Now, apart from the regulatory issue.
And Prof. Abochi, just a second. In fact, a former, deputy governor, who is now the governor of the Bank of Ghana, was to answer for some of these. But as we know, he was also let off on the basis that by an examination of the processes or the docket, there has been an advice that he was not liable or something. So he is now back as the governor of the Bank of Ghana.
Well, as I indicated, look, at this stage, one has to just look at things holistically. From the Attorney General's perspective, the difficulty we have at this stage, and it is a testament of some credit to the current Attorney General that he actually speaks to reasons why he makes decisions the way he does. The truth of the matter is the law allows the Attorney General to make decisions without explanations. And so we would typically not know what informs his decision, in this case, to accept the payment by Dr. Dufour and, bring matters to a close. We will not know the reasons for that. But as I indicated, the justification or one justification that one might proffer is the extenuating circumstance of the cooperation of the parties involved. If a party who is being charged or who has been charged provides sufficient evidence justifying his conduct, if that party cooperates or shows remorse, if that party repents, and if that party ensures that the state ultimately gains something from, or rather the state recovers something from whatever has been looted, so to speak, a decision might be taken, which I might find plausible. This one, on the face of it, the justification for it is the fact that the state has made some money, i.e., the state is not losing entirely in respect to the party involved. The questions about what happens to the balance of the amount involved is one that is a plausible question to be asked by the state. But in the absence of the explanation, we can only second guess. And
the state suggests in an official communication that you are doing a trial, you are expending state resources and money, and it doesn't make sense to continue spending in that regard. I doubt by your experience and in your training of lawyers and even people within the justice system and the Attorney General, you will make this, recommendation that the balance of 2-point-something billion it's okay to let it slide rather than spending state resources to prosecute people over that.
If the state can recover it, I will never make that recommendation. Look, in taxation, there's a principle that you don't use good money to chase after bad money.
That's right.
You don't use resources to look for tax money that you may potentially not get. In some ways, that one might say that may even apply in this case, i.e., if the state deploys resources to get this money back, will the state make it back? Perhaps not. But the counter argument for others would be the state should not necessarily choose to go after the money. And if the state can't get the money back, then the collateral punishment or consequences in criminal justice should apply. So that's the point I'm making, that ultimately, all these considerations are legitimate, but they are speculative. In the absence of the knowledge of the basis, the mechanics, the metrics that went into consideration of why the percentage of amount of money paid is adequate and sufficient and a good basis to foreclose the matter, we might just have adequate information that justifies that. But until then, we can only speculate. All
right. I'm bringing my other guests in to look at the other aspects and financial sense in all of this. But I'd like to end with you on this question. Of course, there were standing trial on charges of willfully causing financial loss to the state, money laundering, and dishonest appropriation of public funds. The Attorney General, in its letter, which it came to the public, said that the decision does not, and I'm quoting them, does not imply an absence of wrongdoing nor a vindication of any conduct. They say this was only practical step aimed at avoiding further legal and administrative cost. So I heard you suggest that because this was not a plea bargain, so to speak, which would have terminated the trial, in a manner that does not allow them to be brought back in future. You are saying that this may be resurrected in future? Would you have it resurrected in future?
I do think that it is plausible this matter may be brought back in future, especially if you have a situation in which a new evidence is discovered. If the Attorney General entered Nolle prosequi as Nolle prosequi, then potentially you can bring it back in future. You can't bring it back in future. But if the Attorney General just withdrew it, or you said
earlier that because of an entry of Nolle prosequi, this matter could be revisited. That's why I asked you the question.
For Nolle prosequi, no. If it was, again, I don't know I have to confess on this. I haven't followed exactly there's withdrawal and there's Nolle prosequi. You can't bring charges in respect of one, but you can bring charges in respect of another for the future. But even for Nolle prosequi, once you can discover a material fact, which wasn't part of the circumstances that led to the withdrawal, a matter withdrawn under Nolle prosequi might just be revisited on new charges. The point is, once you have an additional charge or once you have a tweaking of a charge, the matter is a new charge altogether. So this is not something which is entirely closed. It doesn't stand in the same double jeopardy context as an atrofo convict, where a person might have been convicted and that's it. You can bring back the matter again. In this circumstance, once you can find something which is materially slightly different from the current charge, even for the future, there could be a re-prosecution of the person involved.
Okay, thank you. Prof, stay there for us and let me get my other guest have a bite at this.
Yeah.
How do you feel about it? Some members of the public say, like Martin said, half a loaf is better than none. In fact, the prosecution could have ended in the state getting zero. As we saw in the auto-forcing trial, Japa trial, prosecutions can end in nothing. In that case, some of us blame the Attorney General that the money was actually up for grabs. And he used technicality not to accept it. And now everything was lost. Not a dime is recovered. So some say, if you get 60%, why not?
Well, Samson, let me greet my constituents who brought me here. Also to greet our panelists. I haven't met you on this program for a very long time.
Never been. This is my first time.
Yeah, so it's good to.
He doesn't like me that much.
Okay. Samson, I think.
Okay, so hold on 1 second.
Yes.
So you realize that I didn't invite you here. Right?
I know. Well, you could have.
No.
Over the years.
No. I'm saying this just on a lighter note. Yeah. But I want the public to know something. All of you here, I didn't invite you. Because here, it's a professional program. Unlike elsewhere where the host is just for Kobo, calls people to come and do. Here, until around 9 p.m. last night, I didn't know who was coming on the show. Okay, please go on.
Yes, so, something I would say that this conversation is good for us. It is important that we progress as a nation. And I find it interesting that questions are being asked and the Minister, the Attorney General, has indicated that he will provide more information. On the issue of whether we should cut our losses or we should continue to incur more losses, especially when we are not sure of the outcome of the prosecution. From the point of view of a finance person, I would say I won't throw good money after bad, especially when I'm not too sure whether I even get a dime back. But there is a bigger conversation that we need to have. In some sense, I heard you mention 30 billion being spent on financial sector cleanup. I agree. But people should not think that the 30 billion was spent on saving Unibank. It was spent on the entire financial sector cleanup.
400 plus.
Exactly. So we are looking at 5.7 or 5.8 billion out of 30 billion. What happens to the rest, which is the biggest chunk?
In fact, there's also the other argument,
yes,
which your friends like Obne Japan buys in, that we could have saved 8 billion and not collapse the banks?
Yes, I'll come to that. I'll come to that. So we need to question the decision itself. And it has come to our notice, and based on recent developments, that if for nothing at all, but for regulatory forbearance, we would have lost NIB. Okay? The deposit in NIB is about 6.9 billion. It has cost the current government just a little about 2 billion to save the bank, and therefore not look for 6.9 billion to give to depositors and to save 900 jobs. So quite clearly, it stands to reason that the decisions that were taken need to be interrogated as to whether that was the best decision to make, whether we needed to go spending so much money just to solve a 9 billion problem. Certainly, there are questions there to be answered. And I agree with you when you say that the regulators at the time needed to answer questions. But of course, it's not only the regulators. Let me assure you that no regulator will take out a bank and impose the fiscal burden on the fiscal authorities without their approval. So the finance minister has to go to cabinet and make a case that the state must cough up 30 billion for banks to be dissolved. So we need to ask the government at the time, what was the basis for spending 30 billion and approving a transaction that will lead to the collapse of those banks without interrogating other alternative means of addressing the same problem? So that conversation needs to be had. And it brings about the biggest conversation around making sure that our regulatory processes are so tight, not just to ensure that the quality of our assets in the banking sector are good, but to ensure that the corporate governance processes are able to protect all of us from these type of exigencies. So I would wait to see what my big brother, the Attorney General, will say further. But I think that the country must open a bigger conversation into the decisions, the rationale behind collapsing the banks and spending 30 billion, when it has become very clear that we just avoided a 6.9 billion problem with just 2 billion. You know, and that bank is already making profit. Only recently, they declared that just the first quarter alone, they've made a profit of 74 million Ghana cedis. You know, and jobs have been saved.
What information do you have? Is it actual 60% of this money that has been paid in cash, or its assets that have been recovered that constitute the 60%?
Unfortunately, I don't have those details. You see, the bigger problem that we even have to have is this. Those banks had assets taken over by somebody.
That's right.
There were loan portfolios that were supposed to be recovered by somebody. There were assets of the bank that were supposed to be recovered by somebody. How much is that, and how much of it has been recovered?
Yeah,
that could be far bigger than the figures we are discussing.
We know the GN banks, the
all of
Capital Bank, UT, all their properties across the country were taken over by.
Recently, I saw
consolidated
in the
bank.
papers about the case of
and
Base Bank.
Ghana Commercial Bank.
Yeah, Base Bank. Recently, I saw that he had been successful in the court. I don't know what that means. But that simply means that it is possible to end the trial with nothing in hand.
That's true. Okay, but in the wake of this, in 1 minute, what will you say? Is there a justification to continue to have Atuesian in jail? His liability was 90 million. He paid almost 40 million and said, I beg you, give me time, I'll pay back.
Well, I don't know the circumstances. And here, in fact, I will hire you as a lawyer to explain to me what your thoughts are. I don't have any thoughts on this because I don't have the capacity, you know, to make those judgments that were made at the time, and as to whether at this point in time, Atuesians being incarcerated is justified or not. I think time will tell.
Let's hear from Kojopoku.
Something, I beg you, you give me a bit more time to do two things. I already had my thoughts on the legal issues, which Attorney General, based on filing a Nolle prosequi, I wanted to comment on that. But there's this topic that keeps coming up, and I want to really address it today, since this is one of the most authoritative shows in the country, which is why we have spent, people keep saying that why did we spend 30 billion to collapse banks that we could have spent 8 billion? Let me really put that to rest today. Please help me. Look, banks, before they are collapsed, which the Bank of Ghana withdraw its license, have to be insolvent. So there is an insolvency, meaning that the bank is not fit for purpose. So it's not government. There are two institutions here. There's government and there's Bank of Ghana. All the banks, prior to 2018, in 2016, the Bank of Ghana did what is called an asset quality review, which is to check your non-performing loans as a portfolio, check your asset ratios, your insolvency ratio, and all the ratios that there is. Then there are benchmarks with which you hold your license. You fall below that benchmark, Bank of Ghana will prompt you that, look, bring your insolvency to the benchmarks that is required for you to have your license. Unibank, as far back as 2014, was below those ratios. So it was getting what you call a liquidity support from the Bank of Ghana.
Just like the others.
Yes. But I just want to stick to Unibank for a minute. They got as much as 2.2 billion Ghana cedis from the Bank of Ghana as liquidity support. They were asked to stop their massive expansions that they were doing. They were asked to stop a lot of things that they were doing. They did not listen. They still went ahead and do those things. Apart from government contract, they went into real estate. They went into form all the multimedias and all the things they did, right? So the bank, as all those banks that were collapsed, were insolvent. So it means that they were not fit for their license. When that happens, bear in mind, as of 2017, Unibank had an asset of 5.9 billion, right? Then it had a loan portfolio which was bigger than depositors' money. So the loan portfolio they had at the time, loan and advances, was 3.2 billion. Depositors' money was 2 billion. In that case, it means that people's money are in these banks. Now, if the bank collapses, guess what? Everybody loses their money because the bank is collapsed. So these banks collapsed, not because of anybody. They did not. The mismanagement of the bank has caused the bank to be insolvent, so Bank of Ghana withdrew their license.
Yeah, but there's a difference in expert opinion. One opinion says pump as much as over 30 billion to clean up. Another opinion says you can spend less than 9 billion to rather keep them afloat. Let me get there.
Government doesn't come in. This is a purely Bank of Ghana exercise. Government of Ghana has no business bailing any bank. The banks are private institutions. They do not meet their requirement for their license. The Bank of Ghana withdraws that license. Where the government comes in is governments responsible for depositors. What the Danado government did was borrowed money to pay depositors who have lost their money, not to put it in the bank to save a private bank. It's two different things. So if a private bank fails, the citizens have their money in these banks. They've lost it. I have Kujupuku have said on many platforms that I wouldn't have borrowed that money to pay back depositors' money, because most of the depositors who today are saying ill things about that action got their money back. Most of these depositors, that 30 billion we are saying, went to Ghanaians.
You now want to proceed to...
Now, let's put that to rest, because that 30 billion went to Ghanaians. As long as...
We all have issues with...
Well, you can have issues with, but the fact of the matter is that that 30 billion went to Ghanaians. Now, let me go into the legality of that.
But I need you to know, I need you to note something which I have mentioned before.
Okay.
Of the 420 financial institutions that, according to the Banks and Special Deposit Taking Act, they will have to be affected because of insolvency. There is proof that some were not actually insolvent. There's a matter which is live in court now. I won't talk about it. The Bank of Ghana led them to use their own funds to pay off all depositors and left balance in their accounts for the shareholders and everybody. That shows an institution that was not insolvent.
That's the Bank of Ghana issue.
You wanted to make a small point. Make it quickly.
I just wanted to say that as a government, you have a responsibility to the financial system, first and foremost. So if a bank is insolvent, and you think that by the central, and there's no way the central bank will take that decision without consulting the central government. If you get that consultation, and you are aware, for instance, the Bundesbank or one of the German banks will go there for loan these days. It was a private bank that was struggling. The government of the day didn't collapse it. You could simply say, look, shareholders, we want to come in and support you and save the financial system. Can we agree a system that allows us to get involved as shareholders? Put the part of this 30 billion as shareholders, work with you to turn around the bank and have an exit strategy to give it back to you.
Which is exactly what we do.
Exactly.
Which is CBG.
What you did, so what you do is not to spend 30 billion to pay depositors.
No, but what I'm saying
now, you must also understand that the government's own banks were insolvent. NIB was insolvent, had negative net worth. Was it collapsed? Because government consulted the central bank and agreed to exercise regulatory forbearance. It has kept it for all these years. How did the government...
ADB has some problems.
Exactly.
Okay, so please.
So it is not true to say that because it's a central bank, it's owned by the private person.
Thank you, Adomo.
You can't get involved.
Part of that money was what gave birth to CBG.
Right.
Because when CBG was formed, bear in mind, when you put bad banks together, they don't become a good bank. You put bad banks together, they still have the problem. So government now intervened by pumping money into that company for them to raise new capital. So that happened in CBG. So let's move on. Now,
are you in support of this decision?
No, not at all.
To take 60% and
not at all. And that is where I'm not a lawyer, but I speak to lawyers a lot. And with my little common sense, I wanted to understand a few things. There is a procedural problem for me. When somebody is charged with a crime, he goes to court and he pleads guilty or not guilty. In this case, the 7, including Mr. Dufour, pleaded not guilty. If they pleaded not guilty, they have to now prove their case in court, and the judge will decide whether they are guilty or not.
That's right.
At what point did the AG start negotiating with them? If somebody has pleaded not guilty in court, where is there a negotiation? The other avenue for me is that when you plead...
Let me suggest that to you.
Okay.
So in our everyday practice, and I do this too many times, where I let my clients plead not guilty, even though you may think that they should be pleading guilty, but their first appearance, you let them plead not guilty. Then you begin to negotiate behind closed doors.
Okay.
Then if the negotiation works, you go back and change your plea.
Thank you.
And you can change it to a plea of guilty and then get a plea bargain and get away.
Thank you. So in that case, the only time you can now plead guilty, and then a plea bargaining comes in, and that plea bargain is presented to court as a way to ending the case. Did it happen in this case?
We are not aware of it.
It did not, because the man went to court. He's found not... Because bear in mind, the money retrieval is part of sentencing, because forfeiture is part of sentencing. When you are sentenced, your recovery of the money is part of sentencing. In another jurisdiction, you are given 5 years plus a forfeiture trial. So when you do not recover a certain amount that the court sets, you are now asked to come back and they will add to it. So let's say you are given 5 years and a forfeiture of, let's say, 60% or 80% of the money that you've gotten through ill-gotten gains. Then if you do not recover that money, at the end of your tenure, of your sentencing, you go back to court and the court says, yes, in failure to bring back the 80%, do another 4 years. So forfeiture, which is the recovery of the money, is part of sentencing. What we should remember, and I like what other people have said, that we are now creating an avenue for loot. Because when people realize that you can take enough, do anything that you want to do, and the NDC for me is sad because, bear in mind, they promise us that they are going to protect our public purse. In protecting the public purse, the Minister of Finance, and I like when you read that thing to Professor Abuchi, is that 2.2. They are saying that they don't want to continue because what? They don't want to now go, my brother has repeated it, chase after whatever. Somebody is doing 15 years today, right? How much was her crime? 15 years. So what the state is supposed to go after is the indictment, is the punishment. Forget the money, because a crime has been committed. And as my brother rightfully said, if you now plead not guilty, then prove your case. But if your lawyers negotiate and you want to refund, then there should be an indictment. Because you can't have it both ways. You can't have a no indictment because now, as we speak...
What they have done is to file a Nolle prosequi, which is a power given to Attorney General or the state to, at any time within the trial, decide to stop it.
Yes, so that the person goes away with the money.
Yeah, you don't need any excuse. And Professor Bochi was trying to explain something. We have two of them. We have what we call withdrawal, and we have a Nolle prosequi. When the withdrawal is filed after the prosecution have closed their case, there is an acquittal and discharge. The case cannot be revisited anymore. You understand?
Yes.
In this case, he's explaining to you that this is a Nolle prosequi, and Nolle prosequi does not amount to acquittal. It only amounts to a discharge. So they have said, financial prudence. We don't want to waste more
but
money.
It's not for them. You see, I like the bit where Professor Bochi comes in and says there's a discretion and the Constitution gives discretion and all that. But it's a state's money. I mean, I really don't think that somebody appointed an Attorney General today, 2.2, Attorney General is in court, is in many courts. And rightfully, all the lawyers have said that you give a Nolle prosequi, you don't give explanation. Case ends there because they've done it in several cases, right? There are many Nolle prosequi that no explanation was given. Everybody will speculate and say whatever. But this case, you've opened yourself to the conversation.
It's progressive jurisprudence.
Well, that's fine. But
there's public interest. So if you file a Nolle prosequi, explain.
But the point is that what explanation you are given that you think that you do not want to now chase after that because it is not worth. Attorney General across the country, the state attorneys are in court for 100 cedis, 20 cedis, 50 cedis, people who have stolen goods. They are being prosecuted.
That's right.
So why are you telling me that 2.2 billion is what? Is you don't have enough money to go after 2.2 billion? That is where the state is looking. And especially from a government who told us that they are going to protect our public purse. I think I'll leave it there.
And they are recovering all loots. Yes. Let's see what appears views will be about this. Yes.
So I'll look at it from just the legal side and also the financial side. So on the legal side, I think, as you know, the Constitution empowers the Attorney General to initiate all prosecutions. At the same time, he has the power to discontinue, which is what he has exercised. So the question you ask yourself is, the initiation of the prosecution, at the time these individuals were sent to court, did they comply with the Constitution, which the Constitution enjoins them to? Was it based on fairness, being candid, or was done out of arbitrariness or capriciousness? So that's the first question you ask ourselves.
And remember, it was a different regime.
It was a different regime.
And prosecution is a political decision.
Yes. So if that power to exercise the prosecution is being done or exercised, it has to comply with the requirements which the Constitution also enjoins you. So the Constitution enjoins you to initiate the prosecution. But if you are initiating it, it has to be fair. It has to be candid, and you should comply with that. So if it's born out of bias, then it has to be questioned today. And if it's questioned today, then some of the decisions that have been taken to discontinue will be considered. The other question is, if today we are discontinuing the decision to prosecute, is it also based on fairness? I think the overarching objective of this is to bring justice and also to recover funds that were lost to the state as a result of individuals' action. Yes, you can question the Nolle prosecutor on the basis of political, which is decided case. You can question it like we're going to do. And obviously, the Attorney General will seek to explain the political side maybe on Monday. But for us, we as citizens are looking for justice where it's supposed to be delivered.
Is this justice for you? Does this represent justice? Recovery of 60%?
For me, 100% recovery would have been the best. But if you look at the process that has gone on, there are instances where you've gone through the whole process and recovered nothing.
Correct.
And so for us, the first is to recover the funds and also ensure justice. So individuals who are innocent do not go to prison. And also those who are supposed to go to prison or suffer the punishment. Something, I'll take it beyond the legal side and go to the financial side. So our corporate governance regime must be enhanced, particularly in the banking sector. So there's this principle that Professor Bochi mentioned, that banks cannot fail and banks should not fail. Why? Because when a bank fails, It affects all aspects of the economy. Banks are the fulcrum of our economy. They support the telecom sector, the manufacturing sector, the industry sector, the agri sector. So if a bank fails, all other sectors of the economy are going to be affected adversely. What caused some of the challenges that we have, for which reason people are being prosecuted today? The first one is lack of competent management. So there are instances where people who were in affairs of these banks were not competent and were not the right people. So in the first place, under what circumstances did they get into positions of the board or executive? So how do we address that? The regulator should ensure that there's proper due diligence before people are accepted to be board members of financial institutions. And they should not be related parties, because when you have family and friends on the board, there's no accountability. The second one is to ensure effective risk management. There are instances where loans were given out to people who did not qualify to receive those loans, and yet they received those loans. And the lack of effective risk management can lead to collapse of banks. A few years ago, about 3 banks nearly went down because a loan was granted without effective risk management. The person who took the loan for about 3 or 4 banks failed to use the loan for the purpose for which the person took it. And as a result of that, nearly 3 banks nearly went down. So if you do not have the right people in management, you will see loans being granted to the wrong people. The third is disclosure. If a loan is being granted or a facility is being granted and a board member or any other person in management is a related party to that company, the person must disclose. And the person must recuse himself for the process of granting the loan. If we do not allow those processes to work, then we are going to have the situation that we are having. So in the absence of effective boards, you see instances where these banks are going down. And I'll give you a very good example. So Elon Musk decided to pay himself a huge bonus. What happened? The board members went to court and blocked that bonus. Our board members of banks and financial institutions are empowered to go to court and prevent management from doing what they are supposed to do, or even prevent them from doing what is not right. So Elon Musk, after he failed in that case, because the judge ruled against him, he said judges should not be in the boardroom. But judges should be in the boardroom where the wrong things are being done. And so if our board members are not empowered, they will fail to supervise this, and instances where the person is not even qualified to be on the board, they cannot challenge the decision of management. And so I think we should look at it broadly, that the regulator should enforce the law. The Banking Act empowers the Bank of Ghana to do a lot of things.
How do you feel that you were called upon as a taxpayer to pay money towards this 30 billion that was spent in the cleanup, and yet none of those in charge of regulation, those who were supposed to ensure that what happened did not happen, none whatsoever is answering for it? Not in some other place or in a courtroom.
And I think,
how do you feel about that?
I mean, for me as a person, I feel bad. It's something that we should even not have allowed to happen. And in one of the forums I attended, beyond even we the taxpayers paying, there was a point where financial institutions were asked to pay certain levies to support. These are financial institutions who did not contribute to this mismanagement and collapse of the banks. So a financial institution is being asked to pay additional taxes for the mismanagement by another bank or institution who they were not involved in management. So it is beyond even the citizens, the banks that are doing well and ensuring the right things are done. In one of the international banks, the CEO said some of the things they read about these financial institutions that collapse, they cannot even think of doing them, not even to think of even executing them. They cannot even think, because in an international bank, they have proper controls. And so if you fail to implement the right controls, these things will happen. So as citizens, we are asking the question.
What do you expect to hear from the Attorney General when he brings the explanation about the 60%, which should translate into 3.4 billion Ghana cedis?
I think beyond the recovery of the 60%, are we bringing individuals who mismanage public funds? Because it's a private institution, as said, but as soon as they receive public funds, they are accountable to the state.
Okay. Dr. Drosai, thanks for joining us. Dr. Drosai is also a lawyer, so with his background in auditing and everything, it should come handy, and his background also in governance. Doc, so when we did the Office of Special Prosecutor Act, we put in it that if the special prosecutor ever does a plea bargain, he should explain to us. The Attorney General is not bound to explain, but he is beginning to explain these things. What are you expecting to hear from the Attorney General over this Unibank matter?
Thank you very much,
all eight accused persons standing trial are free.
Thank you very much, Samson, and good morning to my colleagues on the panel and viewers. I think it's a good a step in the right direction. Even though it is not mandatory, it is not required of him to do that. The more you carry the people you lead along, the better they understand some of the basis for the decisions you took. I am expecting him to give us a 360 degrees feedback on what is going to happen going forward. I mean, an explanation on the 60% recovery, like you rightly said, whether it's in asset or in cash, and then how he intends managing that one. And then also how he intends recovering the remaining 40%. And then going forward,
should he be showing evidence of the 60%?
No, I don't think that his press conference would have to show us the evidence. We should have confidence in our Attorney General, and we'll take him by his words.
Why not? Why not? It is our money. This is public money. So if you are recovering, if you say it was stolen in causing financial loss, money laundering, dishonest appropriation, and you are getting it back, we should see the evidence of it, the receipts.
Yes, Samson, I can tell you that if he comes out to tell us that he's recovered and it is cash, and we want further and better particulars of receipt, we'll be able to get it. After all, Samson, you work so hard under the right to information to get the right to information law passed. So we will be able to get it. At this stage, I don't want to doubt him. I want to give him that benefit for him to come and explain the process of recovery, what has been recovered, and the steps he intends taking to putting in place for us to get the remaining 40%. I also want to hear from him what is going to happen to those who contributed to all of this. It is an important factor for me. We had external auditors who were passing the financial statements of these banks. Every now and then, they express a true and fair opinion. Then all of a sudden, there was a crackdown. What is going to happen to these people? There were people working in Bank of Ghana. There were people who were supposed to do certain things. They failed to do that. What are we going to do to bring closure to this matter? I think it's very important.
Doc, you said you want to hear from him what will happen to those who are responsible for this.
That's right.
His government does not share in that policy opinion that the banks should have gone down, that there should have been another approach, not this approach. So a former, governor who was, also implicated in standing trial has been, as it were, also freed and become the governor of the Bank of Ghana. How do you expect him to come and tell you what will happen to anybody else?
Well, I think it does not prevent him from being open and telling us what he intends doing. Because you see, he owes Ghanaians a duty to explain to us what he intends doing. So I think that, look, 60% we've recovered. What are we going to do to the 40%? How do we intend preventing these things from happening in future? Remember, if you are not able to tell us how you intend dealing with the issues, especially those who contributed to all of this, it is likely that it can happen in future. So he needs to carry us along where we are going, and how we intend preventing it.
The previous government that shared this opinion about the causes of the collapse, why it took them over 7 years and they didn't put all the regulatory people on trial, they didn't question them in any forum. Why should this Attorney General take that responsibility on himself?
I think I cannot speak for the previous government. I would not know why they did not take those actions. But for now that we have an Attorney General who is prepared to discontinue a case on 60% recovery, and he intends to clean the system, I think this is the time for us to ask him those questions.
Okay, so as a taxpayer, you are happy that we got some 3 billion, the 2 billion left Famanyame, we should move on?
Not at all. Famanyame, we don't use Famanyame to govern a country. Yes, we've had a 60%. We should push to get the remaining 40%. And those are the things I want to hear from him, how he intends helping us to get the 40%. I'm not happy as a taxpayer that this is happening, but at least it's better you get something.
Doc, the case has been brought to a finality, so he cannot be talking about seeking any other 40% left. It's over.
Samson, let us give him the benefit. Once he comes to explain to us, maybe there are other options available without going to court. So let us give him that benefit.
They don't have any further, responsibility or liability to discharge. They are done.
Yeah, Samson, they are done. But you see, the Attorney General has not disclosed the entire negotiation processes and what was specifically agreed with them. So
he has not said there's anything outstanding.
Yes, he's not said it, but I still believe he can do something. When we want our 40%, how he goes about, because when he was taking the decision for 60%, he never consulted us. And we believe that he's an Attorney General. He's taking the best of decisions with his government. We expect him to find a way.
Look, I still don't understand. If the Attorney General wanted more than 60%, he would have asked for more than 60%. What the Attorney General says they have got is 60%, and they say that is enough. So the matter has ended. And they are actually saying that they are using the 60% as a threshold for some other cases that they will review.
Yes, I can understand where he's coming from, but I will still say that we can have this conversation after he's giving us his rationale or his reasons and what he intends doing. That will give us enough context for this discussion.
But you are happy with this outcome?
I'm happy, not totally happy, but to some extent, once we have something in hand, for me, it's a good sign.
Okay. Professor Abochi, your very final comments on this. Having listened across the finance people, finance energy, finance banking people, having heard the auditors also speak, what will be your final word?
I think there are competing considerations, and the competing considerations are that, one, we want to serve a notice of disincentive. There's a danger of creating a perverse incentive where people might think that indulging in bad behavior actually pays. So you want to prevent that. You want to prevent a culture of people benefiting in a perverse way. But at the same time, you also want to maximize and be efficient in your collection process. And so you want to encourage people to step forward and to be cooperative and to, as it were, help the state recover the money. So you have these competing considerations, and any Attorney General, particularly given the number of prosecutions that are lined up or that are intended, one needs to be efficient, and capacity issues are also there. We may not have the requisite capacity issues, the forensic capabilities, the auditing capabilities, and all the other technical expertise that an office of an Attorney General should have. So all these considerations may go into determining whether or not, under some circumstances, an Attorney General should accept payment that is actually less than optimal. But as I indicated, until we hear the full set of facts informing, or the metrics informing his taking or making of a decision like this, one can only guess and speculate, and in the circumstances, we won't have the full answers.
Okay, please listen to journalist and journalist trainer, and also good governance advocate, Suleiman Ibrahima at the Media Foundation for West Africa. He's talking about a precedent that is being set. The politicians will come in, loot, and then simply say, I'll give you 60% back and let me go. Listen to him.
If you are going into a case and you know that you don't have strong basis, you don't have the evidence to be able to convict, then perhaps you would say, well, if I can get something from this, that's fine. I think that was the issue that came up when eventually the Japa acquittal happened, because people said, well, the Big C company or whatever their name is, at some point was prepared to pay a certain amount, and the AG then turned it down. And it then turns out that we get zero instead of whatever we could have gotten.
Sure.
In that case, we are talking about a situation where the AG says, I believe on this matter, even if I proceed, there's no way I can convict and be able to recover the resources. And under the circumstances, whatever this person has offered, we have accepted it. But if you look at the letter yesterday, that's not it. It concludes by, as Martin was saying, it concludes by saying that this is not to say that there was no wrongdoing. And I'm happy that someone like Martin was part of the oral committee. And oral, we were told, is Operation Recover All Loot. I don't think it was Operation Recover Partial Loot. And I think if we are going by it this way, as I said yesterday, if I misappropriate 100 million cedis or something, to that effect, and then in the end, I know that the system is said that if I put forward, even not 60%, but 70% of whatever has been taken, then I'm going to do away with the 30%. So the example that I said, if it involves 100 million, and I know that if I manage to give out 70 million, I can keep the 30 million cedis for free, then that's an incentive to engage in all manner of things.
Prof, so now the point is that this is bad precedent. And the political group, they will use it. We know what they do in this country. They will use it. Don't you think the Nolle proscribed powers are being abused in this circumstance? So if the trials that have started now don't end by 2028, many will not end by 2028, I can project, and then government changes, and it happens to the NPP, you have given them a good precedent. They will just file Nolle proscribed for all of these people and say, bring 60% of what you have stolen and go free.
Samson, as I indicated, in Nolle proscribed, there's always the possibility of coming back. And so another government, another attorney general, this same attorney general might decide to re-prosecute the accused person for pretty much the same punishment, the same charges that have been brought against him. It's important for us to remember that in justice, there are two aspects of it. We have what is called the restorative justice, and then we have the punitive justice. The restorative justice is where you seek to restore a victim to the state in which he was before the offense. In this case, the victim is the state. The hope is that we are restoring the state to where the state was before the monies were expended in compensating depositors, among others. Question is, if that was what was driving the Attorney General, then that is where the argument of imperfection or an imperfect restoration comes in, i.e. the attempt to restore the state to the status quo ante has not been quite perfect because we haven't recovered exactly the full amount involved. But then again, as I indicated, we don't have the full facts, so I'm not able to speculate. A lot of the discussion will be just open-ended speculation.
Restoring the state, this is actually my final question to you. Restoring the state, as you suggest, back to where it was, even in our court acts, when you are dealing with these matters, you don't only pay the principal to go free. You pay the principal plus restitution. You pay something extra. And that's the purpose of plea bargains that are done. Is that not so?
No, that's correct. But again, these questions, for plea bargain, as you may understand, for plea bargain, sometimes the state loses something for purposes of gaining something. And so, for example, someone may be hiding an asset.
Yeah.
And they will tell you that if you make a disclosure of the assets you have, we are going to ask for zero sentence. We are going to drop charges, among others. So the state makes a concession. I am not sure, and again, I don't have the facts, so I don't know. I don't know if the state's concession is that we are going to let you walk away with a balance if you pay X amount.
All right.
Because somebody may say that, look, if I pay X amount and the state will still prosecute me and get me jailed for a limited time, then I might as well not pay anything at all. Let me just go face the full rigors of the law, come back from jail and enjoy my loot.
All right.
But the consideration could be that the states could be balancing factors here, that let's recover significantly, and then in consideration of losing the portion, he pays us the significant amount. Ultimately, there may be things we don't know. I would like to hear from the Attorney General. That gives me a better perspective in making a much critical consideration and input into this.
All right.
In the circumstances, it's a bit of, we are just speculating, so to speak.
Thank you very much. We took a break here, but Kingsley says that Nolle prosecutorial filed is not an issue to me, but the deal where the AG takes 60%, leaving 40% with no prospect of collecting that remaining amount is worrying. Paying back the 60% to me is evidence of guilt. My question then is, where is the punishment for stealing our money? If there is no jail time, we should certainly retrieve all the loot and not 40% remain in the hands of the accused. It is certainly a bad precedent. We'll be right back.